geopolitical implications. And I'm delighted to moderate this session. And while my experience with space has been almost exclusively on the commercial and private sector side, as national governments and intergovernmental organizations look more and more to commercial suppliers and services providers, the issue of space military activities and applications has become a particularly relevant and topical subject applicable to the entire spectrum of space activities. So I am sure I will learn a great deal from our experienced speakers who will address the proliferation of space military activities and whether and how this threatens international peace and security and jeopardizes our ability to explore and use space sustainably. Today, we will hear from our distinguished panel about the rules governing military space activities, what is allowed, what is prohibited, and what are the inevitable gray zones. We will discuss the prospects for expanding and clarifying the existing international law that controls space militarization and weaponization, and then look at the geopolitical impact that space militarization and weaponization is having on Earth. Before we get started, just a few housekeeping matters additional to what Stefan Michael has mentioned. Please note that the comments, views, and opinions of our speakers are their personal statements and do not necessarily represent the views of the organizations with which they are affiliated or reflect the views of McGill University. Our format today is for our 5 speakers to provide about 10 minutes each on their perspectives about our topic, and then we will have a roundtable discussion among our panelists, followed by a question and answer session. All attendees will be muted, and if you do have any questions, either during or after the presentations, as Stefan Michael mentioned, please send them to our webinar organizers using the Zoom chat function, and we will collect and direct them during our Q&A session. So let's get started. I'd like to introduce our first panelist, Stephen Freeland, who is an emeritus professor of international law at Western Sydney University. He also holds visiting or adjunct positions at various other universities and institutes in Copenhagen, Vienna, Toulouse, Hong Kong, Montreal, Kuala Lumpur, Vancouver, Mumbai, and London. Prior to academia, Stephen had a 20-year career as an international commercial lawyer and an investment banker. He has been an advisor to numerous governments on issues relating to national space legislative frameworks and policy. His experience and accolades in the space law domain are impressive and too voluminous to mention now, and I encourage you to view them in the description of the webinar online. And I can say the same, by the way, for our other speakers too, whom I will introduce only briefly before their respective presentations. Stephen is joining us from Sydney in Australia. So, Stephen, I know you'll set the stage by providing some fundamentals regarding the law that governs armed conflict in space, including some background information on the MILAMOS project, that's the McGill Manual on International Law Applicable to Military Uses of Outer Space and Otherwise. So let me turn the floor to you for your 10-minute initial presentation.
Thank you. Thank you so much, Peter. It's such a pleasure to be here at 10 minutes past 8 in the morning here in Sydney, although I've been up early watching some quite exciting football at the World Cup, and my sincere condolences to Canada. It's not a great day to be talking to a Canadian audience, I know, but I hope you'll all be cheering for Australia in a couple of days. So it's a pleasure to be here. I've done 3 or 4 or 5 previous IASL webinars. My sincere thanks to the Institute, to Acting Director Hanley, to my dear friend Ram Jaku, Stefan Michael, Peter, and everybody associated with this. It's a pleasure to be here. It's amazing. It's such an interesting topic, and I'm very excited to hear all of my colleagues, friends, with their perspectives and also the questions. So Peter has very graciously asked me to give me the easy task in a sense, which is to set the scene. So let me set the scene very briefly with some obvious points, but the obvious points are relevant when we look then at the specifics about military activities in space. Space is, as we're all aware, multifaceted and ubiquitous. There are so many aspects to space. You and I use space every day, 20 or 30 times. I've just been watching the football from Sydney only because of space technology have I been able to do so. So space is a part of every person's life on the planet. I say this with no exaggeration. Every person on the planet is touched by space. And so therefore what we do in space, how we govern space, how we act in space, how we respond to actions in space impacts on every person on the planet. And I think as we talk about military aspects, as we talk about armed conflict that might involve space activities, as we talk about, weapons, we must bear in mind the much broader perspective of space. It is so important to every person's life. A day without space, I know, as you know, that the military is engaged in those sort of exercises, but a day without space would literally send us all back into the dark ages. So this is a really important and weighty topic because, of course, when you start thinking about the notion of military uses of space, and particularly the notion that space itself becomes a theatre of conflict, then the consequences of that are so dramatic. And so let me emphasize that point at the beginning. From a governance perspective, and I have the honor of doing a lot of work, I chair committees at the United Nations Committee on the Peaceful Uses of Outer Space. But from a governance perspective, almost from the beginning of space activities, we've had this dichotomy idea of what space activities are. So from a United Nations perspective, there's lots of interest, but there are two main organizations that look at issues relating to the multilateral international governance of space. The one I've just mentioned, based in Vienna, the United Nations Committee on the Peaceful Uses of Outer Space, that P is important. And then in Geneva, we have another UN body now known as the Conference of Disarmament, whose mandate includes security-related issues, which would include security-related and weapons-related issues in space. And those two bodies were established with those separate mandates, in a sense, when it comes to space, on this assumption, which many people still hold, this assumption that an activity in space is either going to be peaceful, send that down to Vienna, or it's going to be something else, security related, military related, weapons related, we send that down to Geneva. We all know, and this was really highlighted at the beginning of space activities, but exacerbated more and more every day, we all know that that is a false dichotomy. Space is, to many, a classic dual-use area. We all understand what that means, but let me give you an example. There is a major communication satellite, this is obviously on the public record, a geostationary satellite owned and operated by Australian private entity, Optus. It's called Optus C1. It's a geostationary satellite, and it was designed specifically so that half of its payload capacity would be for commercial and civil uses, and the other half would be for use by the Australian Defence Force. So there is a classic design of a satellite that has two dual-use purposes. But you don't even need to look at that clear example. Many, many examples exist of commercial, privately owned and operated space objects that at the same time engage in both civil, commercial, and also are utilized for military purposes. So space is a dual-use domain. This governance dichotomy causes us problems. Having said that, there's much law that relates to space. We're all aware of the Outer Space Treaty and the treaties that followed and all of the other instruments. When I talk to some people about military activities in space and the Outer Space Treaty, they say, well, there's just Article 4, and Article 4 says whatever Article 4 says. Besides that, it's open slather. There is nothing else. You all understand that in interpreting international law treaties, we have rules. We have rules about looking at the object and purpose, and looking at the words in their ordinary meaning in good faith. If you look through every paragraph, every substantive paragraph of the Outer Space Treaty, it has something to say that is relevant to military uses of space. So my point is, the Outer Space Treaty has a lot to say that will be relevant for whatever military uses of space are undertaken. But many people choose to just focus on specific words and say, well, this is prohibited, this is not, therefore I can do whatever I want. But that is a false way of interpreting international law, in my opinion at least. That said, military uses of space have been undertaken since day one. Since I was in nappies, I was born in 1957, Sputnik went up. Since that moment onwards, and given the geopolitical times, space has been utilized for military activities for terrestrial purposes. And if we fast forward to today, every military conflict, every military engagement on Earth is undertaken only when the protagonists can satisfy themselves that they have access to military space activity, space technology. So military uses of space, pardon me, are there. We have principles that regulate how that works. Those military uses of space are for terrestrial purposes. Of course, the more recent rhetoric is now talking about the inevitability of a war in space, the fact that some regard space as a warfighting domain. The rhetoric has ratcheted up, and we really need to sit back and reflect on that. We've addressed this notion of military uses of spaces in many ways. We don't have time to go through that, pardon me, but there have been many dialogues, a group of governmental experts, many resolutions. We have the annual resolution for the prevention of an arms race in outer space. We now have an open-ended working group under the 4th Committee of the General Assembly looking at norms that will build on the existing space principles. Again, I emphasize there's a lot of law already. And of course, we've had recently the discussions about a moratorium on destructive ASAT testing. So there's a lot of work to be done. The Outer Space Treaty also, under Article 3, makes specific reference to the applicability of the United Nations Charter when it comes to activities in space. So activities in space are to be carried out in accordance with the relevant international law that's applicable, including specifically the UN Charter. And so rules relating to clearly Article 2.4, the prohibition on the threat of use of force, Article 51, the inherent right of self-defense in the event of an armed attack, are also applicable to space, but again, in the unique context that space is. Obviously, also, the laws of armed conflict, LOAC, the use in bello, will themselves be applicable to space, but again, within the unique environment that space is. It's not as if Article 3 does not say every piece of terrestrial international law automatically applies to space. Article 3 is much more nuanced than that. We have to work out how terrestrial international law principles apply to that unique environment in space. And so clearly there's a lot of law that will be relevant to the discussion that Jeremy, Jessica, Michael, and Gilles will develop. But there's still uncertainties. Of course there are uncertainties. Some people like to promote that uncertainty to justify their own positions, their own rhetoric, their own actions. In the end, this is such an important issue that we will need to find additional clarity on a multilateral basis. I'm all for multilateral processes. That's why I do what I do at the UN. And I find on these big issues of space, in the end, we will need to find a process that provides additional clarity where there's been a buy-in for all countries. We can't have different countries operating in this already hazardous environment of space and congested environment of space under different rules. And so in the end, those decisions, this is an issue that requires multilateral processes to determine. But in the meantime, Peter very kindly made mention to a project that was led out of McGill, and I've, with my dear friend Ram Jaku, I was the co-editor of what is known as the Milamos Manual. It's a group of experts that have come together over 6 or 7 years. Quite a number of those experts are in the audience, and also Gilles on the panel, and Jessica's been involved, and others have been involved. And the Milamos Manual is the determination by that group of experts of rules that apply to military users of space. The Milamos Manual looks at the period in times of peace and in times of tension leading up to that challenge piece. It does not move on to the law to times of armed conflict, because the whole raison d'etre of the Milamos process was to enunciate the rules that the experts say exist already, and there are 52 of them in the manual, and I encourage you to look at those with the commentaries coming out next year. Those 52 rules are important to stop us getting to the point of armed conflict involving the theatre of space itself. So it is just a group of experts and their views. In the end, that's helpful, but this is a much, much broader issue, and we need to ensure that the fundamental principles that already exist are adhered to, and by and large they are, but they are very relevant. That said, we need to concentrate and focus our minds on the different technologies that mean that perhaps we need to complement existing rules. The open-ended working group is one process. There are other processes, there are other dialogues, and therefore I will stop there. I hope that gives you a background, and look forward to all of my colleagues now building on that. Thank you, Peter, back to you.
Thank you very much, Stephen. And that's a very good way of framing the discussion. I know we'll have some further discussion on some of the specific points, dual use, as you mentioned, very interesting views on military activities for terrestrial purposes and how that affects the existing legal framework and process as well. So great introductory remarks. Thank you very much. Let's go to our second panelist now, and that is Jeremy Grunert. Jeremy is an officer in the U.S. Air Force Judge Advocate General Corps and is an assistant professor of law at the United States Air Force Academy, where he teaches space law and law for Air Force officers. He is the author of The United States Space Force and the Future of American Space Policy, Legal and Policy Implications, and has authored numerous articles on space law. His other academic interests include Middle Eastern politics and history, unmanned aerial vehicles, and military history. Jeremy is joining us from Colorado Springs today. So Professor Grunert has agreed to speak about the geopolitical aspects and national perspectives, including what is planned and what is currently being done, and discuss the prominent military uses of space. Over to you, Jeremy.
Thank you so much, Peter. And I'd like to just begin by thanking McGill University for inviting me on this panel, for thanking Director Hanley for the invitation as well. And thank you to you, Peter, for moderating the panel, Steph and Michael for putting the panel together, and to my co-panelists as well. It's a real honor to be on the panel with you. Thank you so much for your time as well. I know that it's already been stated previously, but I am appearing in my personal capacity, and nothing that I say in the ensuing 10 minutes or later on in this presentation should be construed as the official position of the United States government, the Department of Defense, or the Department of the Air Force. I'm simply here in my personal and academic capacity. Now, what I wanted to just do briefly to begin with was to build on what Professor Freeland had just spoken about, to kind of talk about what it is that we're talking about when we talk about military uses of outer space. And to that end, I just have a couple of quick slides that I wanted to throw up as I was discussing this. And so hopefully the screen share is working appropriately. Somebody please yell at me if it's not. When we talk about military uses of outer space, as Professor Freeland noted, there is a very clear distinction between space weaponization and space militarization. I know that the rhetoric surrounding certain kind of international efforts used to focus on the language of militarization. I believe that that has largely now shifted towards weaponization, because quote unquote militarization has come to be viewed as something that, as Professor Freeland noted, is fairly common and frankly has been ongoing since the beginning of the space age. And so I think that what we can really do is we can divide military uses of outer space into what I've termed kind of space support functions, and then true actual outer space weaponization. And when we consider space support functions, we're talking about the sorts of things that space technology enables that are really there for the purpose, from a military sense, of supporting terrestrial military forces. They are not actual weapons per se in outer space, though some of these space technologies, right, might be used, for example, for the guiding of weapons, right, to certain locations in the terrestrial sphere. But some of these space support functions include the ones that are listed here on the screen. And so many of the most common that we have seen both, again, kind of throughout the space age and applied much more recently, including in conflicts, right, that have just started to take place this very year. Remote sensing would be at the top of that list, right? One of the earliest kind of outer space military-oriented technologies. Frankly, one of the technologies that influenced certainly the way that the United States approached its development of outer space law and its push for the development of outer space law on the international stage. Remote sensing obviously provides very significant military benefits by providing information that would otherwise be unavailable to military decision makers, right? And so one of the photographs here on the screen is, of course, the somewhat infamous photo that President Donald Trump tweeted in 2019 of a launch pad, right, at the Simnon launch facility in Iran. Just one example of the way in which, right, remote sensing can be used to detect information that would otherwise be unavailable, right, to a military decision maker, or frankly, anyone who might benefit from using that sort of technology. GNSS, right, global navigation satellite systems, of course, the GPS system and other similar systems provide critical geonavigational services, not just for the military, but for civilians as well. Communication and mobile network provision is critical, again, both from a civilian commercial perspective and from a military perspective. As Professor Freeland noted, many of these systems, frankly, all of them really, can be dual use. And then, of course, you have other space support functions that space-based technologies can provide as well, including satellite-based intelligence, surveillance, and reconnaissance that goes beyond the traditional realm of remote sensing, as well as actual space tracking and space traffic management functions that these systems can support. On the flip side, you have the actual weaponization of space, actual, no kidding, space weapons. And quite frankly, we haven't really seen a lot of this actually on orbit to date, maybe a little bit. But these sorts of weapons can really be divided into two types. You can have Earth weapons or Earth-based weapons that target space systems. You can see a couple examples of that on the right of the screen, right, including terrestrial jamming and spoofing of satellite or space object signals, as well as the kind of more dramatic terrestrially launched ASAT missiles, right, that can target satellites and destroy them. Something that we have seen several times in the last several years and in the more recent past as well. In terms of actual orbital weapons, again, we haven't really seen a whole lot of orbital weapons. Theoretically, though, some of the more likely orbital weapons could be on-orbit jamming and spoofing weapons, on-orbit ASATs of either kinetic or non-kinetic varieties, right? And so these different types, right, of space systems and these different types of military uses of space are very, very important because, as Professor Freeland noted, if you look at international space law and, frankly, larger international humanitarian law and the laws of war and the like, you can see that there are really a wide array of perfectly lawful military uses of space that a wide range of countries have accepted to be both very, very common and actually lawful, right, under international law and international space law. And so, as Professor Freeland noted, and again, I'm just building off of what he has said so far because I'm the second speaker, and so far that's all we have. So, additional comments for additional speakers to come. But right, one of the things that Professor Freeland said was that no modern military kind of worth its salt would go into a major conflict without first assuring itself that it actually had the ability to utilize its space systems to support its domestic forces. I think this is something that is absolutely true. And frankly, it's something that you can see geopolitically from the perspective of the various countries that play a prominent role in outer space. And so if you look at some of the major kind of geopolitical players, the United States, the United Kingdom, France, China, the Russian Federation, right? All of these countries have a perspective on space that very dramatically emphasizes the use of space systems to support, right, their terrestrial military forces. And so, for example, you can look at the defense space strategies of the United Kingdom and France, for example, two prominent European examples where if you read through those documents, it's quite clear that military uses of space through remote sensing, through ISR, through other support functions like the ones that we talked about on the slide just a moment ago, are recognized to be critical, right? And frankly, if you get into the French defense space strategy, there's a very heavy emphasis on the lawfulness of many of these activities and many of these technologies in what, right, the French military wants to do from a defense standpoint. The United States, of course, has defense space security strategies as well, in addition to its national space policies. All of these things emphasize that peaceful uses of outer space, quote unquote, are what the United States, right, seeks to use and to do in outer space. But there is a very clear definition of these military support functions as being something that falls within that context of peaceful uses of space. And we likely don't really have time to get into the whole history of the so-called, right, non-aggressive versus non-military uses of space. I think that has largely been settled to some degree in the non-aggressive realm, although I'm sure that there are people who would disagree with me on that. But the fact of the matter is that a wide array of countries and all of the major space powers who would be using these systems for any sort of military-related purpose, I think very commonly accept that military support functions certainly are lawful and are something that they really would not, as Dr. Freeland noted, go into a major military engagement without. And you also see, quite frankly, a number of countries, the People's Republic of China, the United States, the Russian Federation, that have either put out documents or stated publicly, right, that they do intend to target, right, these systems in the event of armed conflict, right, that proceeds into certain avenues. Even NATO itself has recognized the fact that space is both critical from a national security and international security standpoint. And last year at the kind of Brussels discussions, recognized the fact that attacks both into and from outer space could potentially, if it came to it, trigger NATO Article 5, right? The collective security article of the NATO agreement. And so all I would say, and I'll just finish up with this again, what we talk about when we talk about military uses of space, I think we have to be somewhat careful and somewhat specific about what we are talking about, because I think that there are certain military-oriented space activities that most countries would agree are either irresponsible or, quite frankly, if we wanted to say so, unlawful. There are others, however, that are widely accepted despite their military-oriented nature. And those, again, would likely fall under those types of military support functions that we had mentioned before. And so with that, I think my time is drawing to a close. Peter, I will turn it back to you, and thank you all so much for your time.
Thank you very much, Jeremy. As you said, careful and specific as we get into this. So great comments to build on Stephen's preliminary comments as well. And your ideas of support functions versus weapons in space, I think is something that I'm sure we're going to be talking further about as we continue, and the inevitable gray areas as we try and determine and classify what may fit under one or the other rubrics. I'd like to turn it over now to Jessica West, who is a senior researcher at Project Plowshares, the Canadian Peace Research Institute, and as the managing editor of the International Space Security Index project. Dr. West's research and policy work is focused on technology, security, and governance, and she interacts regularly with key United Nations bodies tasked with space security and space safety issues. Jessica is joining us from Toronto. And Dr. West will speak to us today about the norms of behavior in space and how they relate to the use of satellites in armed conflict. So over to you, Jessica.
Hi, thank you so much for having me. Yes, I'm going to speak to norms and the role of norms as a governance mechanism in the scenario that has been, I think, eloquently painted by Stephen and by Jeremy. And I think I'm going to begin by picking up the thread that they have given us on false dichotomies. Stephen mentioned the challenge we have in governance because of this embedded false dichotomy between peaceful and non-peaceful, or peaceful and other uses of space. And Jeremy mentioned a few different dichotomies, lawful versus unlawful, military support versus weaponization. And I think that a key challenge we're faced with now in our current military context is that there's a growing number of activities that don't fit. They fall into a gray zone, and I call this sort of a governance gray zone. And what do I mean by that? I mean that there's a growing number of activities where the application of law is either unclear or unagreed upon, such as the threshold of armed conflict or the use of force. And that might describe cyber activities in space, for example, or potentially harmful activities that are intentionally pursued to skirt existing law, such as the law of armed conflict, by being below the threshold of something that would definitely be considered armed violence or the use of force. And again, cyber and other non-kinetic activities fall here. Or the practice of key legal principles that are accepted hasn't been adequately developed yet, such as due regard, where we have a principle, but we don't have very strong practice in place. Or there's dual purpose capabilities being developed and used by military actors that can serve both helpful and harmful applications by both military and civilian users. And this governance gray zone makes the development of new norms of behavior absolutely essential if we want to prevent the possible eruption of violent conflict in space, or what we might call war fighting. So what do I mean by norms? It's one of those words that we use all the time, but it's helpful to explain it in a technical sense. Norms refer to standards of accepted and expected conduct that inform what it means to be a good or a bad actor. Norms inform and are reflected in behavior and the things that we do. So not law, but activities. The behaviors are rooted in shared values and social expectations about what is appropriate. And shared expectations are key here. And there's a strong sense or a social and moral obligation to comply, or a certain oughtness to them. I think it's really important to point out that when we talk about norms as a governance tool, this is not separate from or in competition with legal frameworks, such as the Outer Space Treaty or the UN Charter. Norms and law are complementary. Law provides core principles and values that inform appropriate behavior. And in turn, norms often fill in the details of law by illustrating what the law looks like in practice, how it's implemented. Importantly, when we go back to the point about dichotomies, sometimes norms can help inform behaviors and activities that, while legal, might be undesirable or dangerous, and vice versa, while not mandatory, might be particularly desirable and helpful. And so norms are absolutely essential to making social interactions function smoothly. Often we don't even realize when they're helping us in these situations. And I think we notice them more when they're violated. And you've probably been in this situation at one point or another if you've traveled to a different part of the world and you've experienced yourself making certain social faux pas on public transit or on escalators or when visiting someone's home. And these behaviors aren't prohibited, but they reveal you to be at best clueless and at worst a bad actor. And the same approach to norms can apply in international relations, including in space. Here, I think it's really important to point out, just like we have law in space that applies to military activities, we also have norms in space. And the international community has been active in recent years to flesh out that normative framework. I think the development of the long-term sustainability guidelines at the UN Committee on the Peaceful Uses of Outer Space is a really great example of an effort to develop environmental and sustainability-oriented norms, such as debris mitigation rules, end-of-life practices on orbit, and so forth. But there's gaps. And we also have norms that are not good norms. Just because something is normal doesn't make it good or beneficial for us. And in particular, there's a really big gap when it comes to norms or standards of behaviors that are aimed at maintaining peace and security in outer space. My colleague Gilles Doucet is going to speak shortly. We spent quite a bit of time 2 years ago mapping out existing norms. And while there were a lot related to safety and sustainability, there just were not very many when it came to military uses of outer space and efforts to prevent conflict. And in essence, this lack of rules when it comes to military activities or lack of best practices is itself a norm. And I think it's rooted in the principle of freedom of action. The idea that there are very few restrictions when it comes to uses of space. But this norm isn't helping us anymore, particularly at a time of rising geopolitical competition and new capabilities in space. Likewise, we also have some bad norms, such as the practice of testing destructive anti-satellite weapons against one's own satellite, which can create a mess of debris. And that over time emerged as something that was normatively acceptable, but it doesn't make it good. So we need more norms in space, and we need better norms in space, particularly when it comes to military competition. And I'm going to point out a few ways in which I think norms can help the current scenario. First, norms can make military activity safer. When we look to other domains, there's the example of the Incidents at Sea Agreement, which included rules to prevent collisions, to avoid interference, to limit dangerous maneuvers, to use clear signals, to provide prior notification before certain activities that might be deemed threatening. And the goal here was to enhance mutual knowledge of military activities, to reduce possible accidents or conflict, and to increase stability. And I think that same approach would be very beneficial in space. Second, norms can help to avoid misinterpretation and unintentional conflict. Norms are absolutely essential to how we interpret the behaviors and the intentions of others. They help us to know when to worry about something and when not to worry about something. And this is really important when we're talking about below threshold activities that might be deemed threatening, but don't cross the threshold into armed conflict. For example, in the absence of norms associated with close approaches or inspections by foreign satellites, operators rightfully worry about a state's intent and what the outcome of that scenario might be. Is this a friend or a foe action? Is this benign or harmful? But if we had accepted standards of behavior, if we had accepted practices that we pursued prior to such activities, it would help to reduce some of the uncertainty and also understand what intentions are, and that can avoid escalation. Tools that help us interpret behavior also avoid misinterpretation, which is a key driver of conflict. and they can help states design activities in a way that don't make other states feel threatened. Norms can also help address some of the insecurity and instability that is derived from the use of potentially threatening capabilities, especially those linked to emerging technologies that are often dual purpose, as Stephen mentioned, meaning that they can be used for different ends and for both civilian and commercial purposes. Advanced robotics and close proximity operations might be examples. A behavioral focus on norms shifts the focus from the capability itself, which can be very widespread and used by many different actors, to how it's used. And norms of behavior can help differentiate these uses and signal intent. And this is becoming important in the context of active debris removal and satellite servicing, for example. Finally, norms can help to set limits on what's acceptable, including uses of specific capabilities or effects. Many of our existing arms control agreements emerged out of prior normative restrictions. That includes examples such as the use of nuclear weapons or chemical weapons. We're seeing similar emergence of normative limits right now in space when it comes to the creation of space debris. So we can use normative tools to help adopt additional limits and strengthen them. That said, we need to do more of this work. And so how do we get there? Stephen mentioned one example that's currently underway. There's an international effort to begin identifying and hopefully implementing new norms of responsible behavior in space. This is under the mandate of the United Nations Open-Ended Working Group on Reducing Space Threats. This group, which is open to participation by all states, has thus far completed 2 out of 4 meetings. I've been able and lucky to attend and participate in the discussions, and they've been incredibly substantive. Although there are diverse priorities, there are core themes that are beginning to emerge. These include key principles and objectives such as conflict prevention, environmental protection, and civilian protection. And there's also a growing sense of the types of behaviors that can be adopted to help achieve these objectives, which are strongly linked to Article 9 of the Outer Space Treaty, focused on due regard. And some of these include providing prior notification, coordinating activities, communicating and exchanging information on military activities, engaging in consultations and deconfliction. We also have an example right now of a unilateral turning into multilateral effort to change the existing norm when it comes to destructive anti-satellite tests, being led by the United States, with an effort to ban or to adopt voluntary moratoriums on such testing. And that's a different way in which norms can be created. And here I just want to wrap up by saying that I've been focusing on norms and the value they bring to governance. And I think it's important to remember that norms are necessary but insufficient for the prevention of conflict and the maintenance of peace and security in space. Norms aren't a standalone solution. To make them work, we need other tools and mechanisms to implement them and to observe compliance with them so that we know that norms are being observed by others. In other words, we need more institutional hardware for space to facilitate the kinds of practices that we want to engage in and that we expect others to engage in, and to share data and knowledge about what's happening in space. We also need further agreements on key objectives and principles to inform norms. For example, there's clearly disagreements right now on the use of force or the deployment of weapons, however those are defined, or the protection or non-interference with civilian critical infrastructure. And finally, I think we probably need to include some hard limits on what is allowable in outer space. And these can begin as norms, as we've seen in other domains, but we might have to advance them through further legal agreements at some point, and really set out the parameters of hard acceptance and non-acceptance in outer space, and I guess the limits of some of the dichotomies we've been speaking to. Thank you.
Thank you very much, Jessica, and very interesting to hear about, and hopefully we'll have a chance to also discuss further the important issues you've raised, false dichotomies, the governance gray zone, and really how norms can evolve into rules and legal formalities as well. So very much appreciate that overview. Next, I'd like to call on Michael Byers. Michael holds the Canada Research Chair in Global Politics and International Law. His work focuses on outer space, Arctic sovereignty, about which he has written a prize-winning book, climate change, the law of the sea, the laws of war, and Canadian foreign and defense policy. Dr. Byers has held teaching positions at the universities of Oxford, Duke, Cape Town, Tel Aviv, Nord in Norway, and Novosibirsk in Russia. Michael is joining us from Salt Spring Island in British Columbia, and Professor Byers will comment on considering space security aspects, the consequences of the use of commercial satellites in armed conflict, and the particular issues around the potential militarization of cislunar space. Over to you, Michael.
Thank you, Peter. And let me just repeat Stephen Freeland's thanks to everyone involved in organizing this workshop and my fellow participants, and also this amazing audience. I've been going through the names of the audience members, and some of the real expertise is actually in the audience and not just on the panel. So thank you to everyone. I want to begin by disagreeing with my friend Jessica about one thing, and that I want to suggest that we are seeing, we are in the middle of the development of a new rule of customary international law, prohibiting the testing of kinetic anti-satellite weapons in a way that creates dangerous debris. And part of the state practice and opinion juris that's contributing to this rule involves the dozen or so unilateral declarations we've seen this year of states saying that they commit to never testing kinetic ASAT weapons. But it also concerns some of the past practice. So for instance, in 2019, India tested a ground-based missile against one of its own satellites, but emphatically reassured everyone in advance that no dangerous debris would be created. Now, as it happened, they did create some dangerous debris, but the point was that they sought not to. And even most recently in November 2021, when Russia recklessly engaged in a kinetic ASAT test against a Soviet-era satellite at an altitude of 480 kilometers, they emphatically denied that any dangerous debris had been created. Now, that was a false assertion. We know that dangerous debris was created. The International Space Station has had to boost itself out of the way of incoming debris from that test on a number of occasions. But the point was that the tribute that vice paid to virtue, the concealment or the denial, is the practice that matters, much more so than the act itself, in terms of the formation of customary international law. And I'm confident that we are now seeing the growth of a global awareness of the dangers to all spacefaring countries of these kinds of tests. And let me just show you a single plot that my colleague and co-author Aaron Boley produced shortly after the Russian test. And he looks up at his. Okay, and you should be able to see a plot. Can everyone see a plot with a bunch of nice lines on it? All right. Let me explain this very briefly. This is a full orbital revolution. It's showing the debris as of the 7th of December, so roughly 3 weeks after the test. This is the trackable debris that had been tracked up to that point. So pieces roughly 10 centimeters in diameter or larger. There's a lot more smaller but still lethal debris, thousands and thousands of pieces. This is the trackable stuff. And this is the stuff, again, that had only been tracked up to the 7th of December. A lot more was tracked later, but it just gets too dense on the plot to even bother including them. So this is illustrative. So the important point here is that the actual strike happened at 480 kilometers. But the amount of energy involved in the strike was so very high that it sent debris in all directions into elliptical orbits. And the debris that went into elliptical orbits is crossing all of the orbits of other space objects in low Earth orbit. So, and we actually show some of these. So the constellation that was most exposed to the strike was SkySat, which is actually owned by Planet. And they should be particularly unhappy about what happened, because you see an awful lot of gray close to their constellation. But Starlink's 550 kilometer constellation is in a lot of it as well, and that includes some 3,000 Starlink satellites. So bad day for SpaceX. But even higher up, Iridium was put at risk. Even OneWeb at 1,200 kilometers was put at some risk. And then look below the strike altitude, and you see the International Space Station, the black dots. That's why the space station has had to maneuver so much, including just last month, right? Some of this debris has remained in orbit for a year now. And then just below the ISS, the Chinese Tiangong space station. So Russia's most important ally should be royally pissed off at the Russian military for conducting this test and putting its taikonauts at risk. But the reason I'm showing this to you is that every spacefaring state has an interest in making sure that these tests do not happen in the future. And that mutual interest is the basis for state practice and opinion juris that can lead to the development of a rule of customary international law. So I think with regards to testing, we're getting there. And I salute the United States government for taking the lead by making the first unilateral declaration, because that actually could be the snowball that creates the avalanche of state practice in favor of such a rule. But I'm going to stop sharing my screen now and just go back to a discussion, because I want to get to the issue that I find most interesting, and that is at the heart of this workshop, and that is the involvement of commercial actors. And the most remarkable thing that I think happened with regards to space security this year was two CEOs of satellite companies publicly declaring that they were providing support to the Ukrainian military. One was Elon Musk with regards to providing Starlink services in support of the Ukrainian military. And the other was Mike Greenly, the CEO of Canada's MDA, declaring that MDA would be providing imagery in support of the Ukrainian military from its RadarSat-2 satellite. And this is different from countries using their own military satellites to support an ally. These are private entities that in the course of their normal business sell imagery or communication services to foreign governments. But this particular foreign government, the Ukrainian government, is in an armed conflict with another country. It's a full-scale armed conflict. Laws of war apply. There are belligerents and there are non-belligerents. And Western countries, including the United States and Canada, have been very careful to avoid stepping over the line and becoming belligerents themselves. That's why there's no no-fly zone over Ukraine. Western countries do not want to become that involved. But these space companies are behaving like private military contractors did in Iraq. They are providing essential services to the military campaign in an active shooting war. And let me just suggest that a military contractor that is providing targeting information. So let's say someone who is running coordinates to the front line is a legitimate target under the laws of war. So is RadarSat-2 imagery provided to the Ukrainian military showing Russian military installations and Russian heavy equipment a legitimate target under the laws of war? Well, you can do that in analysis and From a Russian perspective, it most certainly does constitute a legitimate target, RadarSat-2. Or if you take Starlink on SpaceX, SpaceX is providing communications that enable drone operators to talk to artillery operators, providing the real-time targeting information, directional information necessary for the success of artillery operations. So that's like a runner taking information to the front line. Is a Starlink satellite providing that information, or is the Starlink infrastructure more broadly a legitimate target? I could certainly make the case if I was a Russian international lawyer. So we're into a very difficult phase here in terms of analyzing armed conflict, the laws of war and other laws that apply. And also, I would suggest the policies of Western governments, and the question as to whether or not they want to limit these kinds of commercial contributions, whether we could risk being drawn into a war by the actions of our corporate entities. And the final question, and Peter just mentioned this, and I'll put this on the table, is that up until now, there has been no military involvement in what's called cislunar space, the area between geosynchronous orbit and the orbits around the moon, lunar orbits and the L points. But there are moves, including by the US military, to build spacecraft, to go there, to do military things. And I would just like to suggest that now would be a good time for states to come together and to draw a line and say, no, we're actually going to not allow this to happen, that it's not in our interest to see the militarization of the entire solar system. Let's draw the line at Earth orbit, and then work at reducing the risk of military conflict in Earth orbit rather than letting it spill over into cislunar space and deep space. But that's enough for me. I'm really looking forward to the discussion. Thank you so much.
Thank you very much, Michael. It's very helpful to be coming up with some specific examples. I hope we can discuss a little bit more about that and see how it evolves, not only in terms of those applications terrestrially, but as you say, in other domains, cislunar orbit and otherwise, because that's really where we have to address some of the issues that are going to become more and more issues of concern. And also interesting observation about the evolution of customary international laws. We go from norms, hopefully, to some more specific rules at some point. But thank you very much for setting the stage for that discussion as well. Now let me turn to our fifth panelist, and that is Gilles Doucet. He is an independent space security consultant, the president of Spectrum Space Security, Inc., and technical consultant for ABH Aerospace. He focuses on the convergence of satellite technology, military space applications, space governance, and international space security cooperation. Gilles is the technical lead for the Milamos project, and he's also on the visiting faculty of the cybersecurity LLM program at St. Thomas University School of Law in Miami, and instructs in satellite and space security. Before founding Spectrum Security, Gilles spent 35 years as a research scientist with the Canadian Department of National Defence, conducting studies and assessments on space technology, military applications, and advising on space policy, international cooperation, and defense diplomacy. Gilles joins us from Ottawa today. And for his presentation, Professor Doucet will cover a few interrelated themes, and we've heard some of them already. First, military uses of space from a historical context, its evolution from strategic to tactical use, both stabilizing and destabilizing, and how this has motivated a rise in counterspace developments, and the ramifications of the convergence of military and commercial use of space. So over to you, Gilles, please.
Thank you very much, Peter, and thanks to my fellow panelists. Some of the topics that I'm going to raise have already been introduced, so it makes my job a little bit easier. I'd like to take the perspective from the space infrastructure perspective and talk about some major transitions that have happened over the past several decades that have that have led us to this situation, the security issue that we have that melds not just military, but also very commercial interests and essentially all of society's interests. So if you'll permit me, I'll just share my screen. I have a few slides. So you should be seeing my introductory slide. So now I'm going to talk about the first transition historically, which has gone what I call from strategic space to tactical space, which has created, taken a stabilizing effect to a destabilizing effect. So if we go historically, the early days of the space age, Cold War era, two superpowers, basically from the 60s to the 80s, we had film-based imagery. That was very slow. Capsules would take images on film. It would take a few days for the capsules to be deorbited, processed. And so by the time military users received the imagery, it could be anywhere from a few days to a few weeks. It was not useful for tactical operations. However, it was very useful for keeping tabs on your opponent and very useful for verifying arms control treaties. And in fact, without space surveillance, it's unlikely that we would have had the SALT and the START agreements between the US and the USSR, because national technical means, such as satellites, were used to verify those treaties. There were navigation satellites as well, lowered orbit navigation satellites that used a Doppler process to provide approximate navigation solutions, mostly to the Navy and especially the ballistic missile submarines. They were not that accurate and they were not persistent, but it was important that it kept the nuclear deterrent viable. Again, a stabilizing factor. Early warning satellites use infrared from high orbits, geostationary or high elliptical orbits. They could detect ICBMs and space launches, and that gave 30 minutes warning instead of 10 minutes warning that you get from radars of a nuclear attack. It gave a second source of verification. Again, this was a stabilizing factor. And for communications, large terminals were needed, fixed installations, you didn't have the mobility. If you look at the present time, starting in late 80s, early 90s, we transitioned to digital imagery, where the image is transmitted through radio frequency link. Military forces on the ground can receive it within minutes or sometimes in near real time. Then that imagery can be used in operations. The GNSS, so the global navigation satellites, the GPS and others, such as Beidou, GLONASS, now provide precise timing and positioning information. Not only can military forces use them to navigate at sea, in the air, on the ground, but they also guide, as you know, precision weapons. The infrared technology, infrared sensors now are much more sensitive than in the past. So not only can they detect very large emissions, such as ICBMs or space launch vehicles, but much smaller emissions that can be used tactically. And again, for communications, plethora of services being provided to very small terminals, very mobile, so troops in the field can receive information instantaneously. Bottom line is that satellites are now a threat to opposing forces, rather than being something strategic that had a generally stabilizing nature. So now they are part of the kill chain, as Professor Byers mentioned. Second transition that we've encountered the increasing capability of and sophistication of commercial systems. And this has led to two types of things. One, a tremendous increase in the military use of commercial systems. And again, that was just mentioned now in the Ukraine-Russia conflict, commercial systems are providing direct support to military. And also at the same time, civilian critical infrastructure has become much more reliant on space capabilities. So we have this convergence, I guess, of civil commercial interests and military commercial interests. And there are a lot more dual use satellites than there used to be. I mean, satellites that have customers, both civil customers and military customers. And our critical infrastructure is not only dependent on these dual use commercial satellites, but they are dependent on military systems. So the GNSS satellites, the GPS, for example, are critical to our civil infrastructure, and they're owned and operated by the military. So we have this convergence, blurring of lines, if you want. It makes it much harder from an international law perspective as well. Just a few types of critical infrastructure that rely to a small or large degree on space services. So communications, energy, transportation, our food supply. Food supply relies on transportation, but also remote sensing satellites are a tremendous boon to agriculture, as well as GNSS for precision agriculture. Healthcare relies on communications, relies on energy. Financial services, a lot of transactions are timestamped with GPS timestamps, enabling those proper functioning of markets and transactions. And a lot of ATMs and other types of credit card transactions rely on satellite communications. Emergency services, disaster relief, disaster mitigation. We could go on. This could be a huge topic, but the main point is that we are reliant on space services for our civil society infrastructure, and that trend is increasing as we develop more and more competent and capable space systems. We learn new ways to use them more efficiently. So we have an increasing reliance on space for our civil infrastructure, but we also have a more threatening atmosphere in space. And I'd like to just do a few words here on counterspace, just to set the scene. So we hear a lot of talk about ASATs. Militaries don't talk about ASAT, they talk about counterspace. And because space systems have become so important to military operations, other militaries wish to reduce that effectiveness. So in general terms, counterspace is to negate or reduce the effectiveness of another nation's space capabilities. Doesn't mean you have to blow up things, doesn't mean you have to destroy satellites. There are many, many ways to do it. I bring it up because from an international law perspective, each of these different techniques or these different activities might have, or generally do have, different implications in international law. So I'll just do a quick summary. On the bottom, you see space situational awareness. That is fundamental to any type of counterspace activity. If you don't know what your adversary is doing, where their satellites are, what the capabilities their satellites are, perhaps what frequencies of radio the links they're using, then you can't do much counterspace at all. So that's a fundamental baseline knowledge. But things you can do are sometimes quite passive. You can do camouflage, concealment, deception. You can control your radio frequency emissions so they can't detect you. That's on the left-hand side in the green. These types of activities have been going on for a long time, even before space activities, because these were activities to counter aerial reconnaissance or to counter electronic warfare intelligence. You can do interference, radio frequency interference. We hear about that a lot. And there's some technicalities to that. The radio frequency interference with a satellite system can be either uplink interference or downlink interference. So uplink interference is actually what it means. You transmit perhaps an interference signal up to the satellite. The satellite will rebroadcast it, and that will mix in with the intended messages of the users, so that the users cannot decipher and extract their message from the noise. That tends to affect a wide area based on how the area coverage of the satellite. You can do downlink interference, which is where you are targeting the user on the ground. the receiver. And so the satellite has no knowledge of the interference. The satellite suffers no effects. There is no activity in space. You are interfering with the space services, but from the ground perspective. And that's pretty much all the cases of GNSS interference or GPS interference. They're all attack the receiver on the ground. The satellites themselves are undisturbed. Their control centers are undisturbed. It's only the individual users, and they usually have a local effect. There's 3 different ways that you can interfere with the GNSS. Through jamming, where the receiver cannot decipher the signals from the satellite. Therefore, the receiver does not give you a position solution. You can do spoofing, where you're generating a false signal. The receiver receives all those signals from the satellites, plus receives your false signal, and therefore calculates an incorrect solution. Or you can do weaponisation, which is you actually receive and delay the signals from the satellite and retransmit it, again, resulting in a false navigation signal from the receiver. But all of this happens on the ground, or in the air, or on the ocean, depending on your location. Other types of interference deal with laser dazzling, we may have heard of, and that's intended to interfere only with electro-optical satellites, remote sensing satellites that use electro-optics. They will not affect synthetic aperture radar satellites, such as RadarSat or the RadarSat Constellation mission. However, you can interfere with those by a radio frequency signal by transmitting false returns. You can, if you were to transmit a very large, powerful laser into an electro-optical satellite, rather than just temporarily dazzling it, in other words, a reversible effect, you can actually damage the sensors. Then you are causing damage to that space object. There's different elements of international law there. It's not the liability convention because the damage was not caused by a space object, it was caused by a signal from the ground, but there's still general international law implications. And we hear a lot about orbital ASATs, rendezvous, proximity operations, orbital ASATs. That's another way to cause interference or damage to a satellite by approaching it in near proximity. That in itself is not a violation of any law, but if you were to then interfere through radio frequency or physical manipulation, then you can cause damage. And I do want at this point, I guess, to mention a pet peeve of mine is the belief, the false belief that some people have that any satellite can become an ASAT by being directed onto another satellite in orbit. In technical terms, that is not feasible. We don't know the tracking of the satellite. We can't track the satellites well enough. We do not understand the gravitational models and the drag profiles well enough. We cannot, the satellites, a normal satellite has not been designed with the attitude control and propulsion control to a fine degree enough to be actual to make an engagement. And they're not equipped with a terminal guidance sensor to do that. So that is not an issue. We hear about it sometimes. What could be an issue are satellites that are designed to actually conduct proximity and rendezvous operations, such as orbital servicing system or debris removal, but that is just a handful of satellites amongst the thousands. And then a final word on cyber. Cyber can be used to interfere with satellite services. 95% of the cyber issues are on the ground. They're with the user network. It is difficult to actually conduct a cyber operation into the satellite. And in most of the things we hear about are interfering with the user network. So for example, the via satellite cyber, the attack against the via satellite system at the start of the Ukraine war through cyber means disabled thousands of modems on the ground. This is a good example of convergence of military and civil users on the same satellite. Ukrainian military were some of the users, but there were thousands of other civil users. And it ended up disabling part of the electrical grid in Germany. Some of the windmills generating electricity had problems. But that was not an attack on the satellite itself. The satellite was undisturbed. It was the cyber attackers used the satellite to transmit the information to the modems on the users. Anyway, just a quick summary here to say that there are many different aspects to counterspace, and the international law perspective would be different in different cases. So the facts of the case are very important. So I'd like to conclude, with the two statements here is that essential civilian services have never been more reliant on space systems, and those space systems have never been under so much threat. And we have the issue of commercial military integration, so used by the military of commercial systems and used by civil society of military systems. And not to mention the issue of orbital debris, which has already been raised, and that's throwing just an extra challenge into there. And I'll just stop my sharing here and pass it on. Peter, that's my main points.
Thank you very much, Gilles. And I just want to say how impressed and grateful I am to all of the panelists. I know it's very difficult to contain the discussion to just a short 10-15 minutes. So very well done. You've stuck to the topics very well, but now we've got a couple of questions. Perhaps before getting to the chat room, it would be a good idea just to go around the table again with our panelists who have been listening to comments of their fellow panelists to see if there's any follow-up observations or comments. Let's start at the top. Stephen, you were very kind to come up with the framework. Any thoughts or comments on anything that you've heard from the other panelists?
Thank you, Peter, and thanks, Jeremy and Jessica and Michael and Gilles. I mean, you're good friends, but you're just amazing commentators, and I've learned so much. I'll be brief, but I have a few quick reflections on some of the comments that were made, if you'll forgive me, and thanks for letting me take the floor. Jeremy's talk about NATO and Article 4 and self-defense and issues like that raised an interesting issue for me, and I'll throw a question out to everybody to consider. So we all understand, and I've heard many military people say that actions against, let's say, one country's space infrastructure could constitute, depending on the circumstances, an armed attack, which justifies self-defense. That self-defense could be manifested in an action terrestrially on Earth. Okay, so I accept that, you know, there are wrinkles on that. But what about the other way around? Because my issue here is space is a unique environment because of all of the consequences of actions that are done in space for everybody else, which makes proportionality of action and all that very difficult. So picture this, an armed attack but from state A against state B terrestrially. Would that justify an act of self-defense, so that there's a legitimate right of self-defense? Would that justify an act of self-defense extraterrestrially in space? When I speak to military people, of course, they say, of course, we reserve every option and we will undertake an activity that is in our best interest, etc. I just leave that there. Obviously, some of the actions in self-defense in space that Gilles described, perhaps temporary, etc. But you know, you could take that to an extreme. So does stuff on Earth justify counteractions in space? Secondly, on the norms thing, thank you, Jessica, so much. norms are important, but my message is there's a lot of law already in place, and we have to ensure that these norms, as you quite rightly said, are not seen as replacements. So when the Russian ASAT test took place late last year, everybody, countries and commentators all said quite rightly, this is irresponsible, this is unacceptable. Nobody, myself excluded, because I did, but very few people said this is illegal, this is unlawful. Now, there's a whole lot of reasons why. Either people don't think it is, or there's geopolitical reasons why they wouldn't say it. But if you were asking me to draft a statement of claim in response to, it doesn't have to be Russia's, but depending on the circumstances, in response to a direct ASAT attack, which deliberately causes, reckless amounts of debris, I could draft 10 points in that statement of claim based on not only the Outer Space Treaty and space law, but on other parts of international law. Now, I might be wrong on 8 of them, but I will be right on 2 of them. And so I think we need to bring law back into this equation. As I said in my remarks, law has a lot to say already. The norms, as Jessica said, are incredibly important to build on it, but I desperately hope that in the preamble of whatever comes out of the Open-Ended Working Group, it says we already have existing law, these norms or principles or whatever come out, build on that. Thirdly, on the customary international law question, Michael, we're good friends, but I slightly disagree with your presumption about that we're moving towards a customary international law principle. Doesn't matter what I think. But I just draw an analogy, and analogies are dangerous, between what's going on in terms of the movement towards the prohibition of nuclear weapons. So we have a treaty in place, binding treaty in place. I don't remember the ratification numbers, but I know it's a significant number of countries have ratified, and a very significant number of countries have signed that. Of course, none of the nuclear power states support or accept that. But there's another example of a lot of activity being taken place. And one could argue on analogy. I know these are different, and I know you're not saying this, Michael, but it would be very difficult, sadly, in my opinion, to argue that there now is a customary international law norm prohibiting the use of nuclear weapons. Sadly, because the nuclear power states, those most directly affected by this norm, themselves oppose that. And so it's not the same as the ASAT test. I agree with you that there's a strong momentum, but I think we just have to be very careful, in my opinion, to begin to rely on issues of customary international law, because you know how damn hard it is to actually prove that if you make the assertion. But I agree with the momentum. And then one more thing you said, and then I'll stop, Peter, about, and I think it's a really important point, that about the Starlink and the MDA examples, that great examples. They, as Michael quite rightly says, from a Russian perspective, if they're doing all of the questions that you ask under the laws of armed conflict about whether something becomes a legitimate target, they could satisfy themselves that some of these satellites might represent legitimate targets, although what they do with that is not clear. But you could take the extension even further, and this is something we have to, be careful about. Could at some point that be extended to the fact that those civilian operators of those satellites sitting in wherever they're sitting, operating satellites that are quite clearly supporting, in this case, Ukraine, could they at some point themselves be regarded as combatants and therefore legitimate targets? Now, I'm not saying they are, but I'm saying, we're moving into the territory of, things that we haven't really considered before. But if I'm an operator operating those Starlink satellites, I'm just going to be a little bit more nervous now than I was before. Now, I know that many of you will disagree with what I've said on these 4 points, but I just raised them for the discussion. And thank you, everybody, for such wonderful comments. Thank you, Peter, for giving me the floor.
Thank you very much, Stephen. And before turning it over to Michael, maybe to respond at least on the second and third points dealing with kinetic and ASAT satellites, as well as customary international law. Stephen, I don't want to leave you off the hook on your first question. And it actually corresponds to a question we have from the chat room as well in some ways. Can a state destroy a satellite of another state if that satellite is spying? Which is a version of the question that you had first posed but did not answer. So what's your answer to that question? And maybe then I'll turn it over to Michael. Maybe you have also a view on that, and then talk about the other 2 points. Let's turn to you first, Stephen. You can't just get away with asking a question without giving us an answer.
Oh, thank you so much, and thank you for the question. It's a great question. Obviously, as Michael has quite rightly said, everything is fact specific. So clearly we need to look at the facts. Any legitimate action to destroy that satellite would have to be justified in a legal way, let us presume, by virtue of an act of self-defense. Self-defense, at least under the Charter, now, I'm putting aside customary international law because, as I said, that's a tough issue, requires an armed attack. So to even justify even thinking about this as, there has to be a conflict in place. But assuming that is the case, then applying what Michael said, it may well be that the state regards, having asked all those questions, that this satellite is a legitimate target of war. But once you do that, your response also requires questions. And one of your responses is, is there a military advantage? Have you distinguished? So yes, it's a legitimate target in my mind's eye. Is there a military advantage in taking an action and taking it out? Yes, there is. What's your third test? Proportionality. And what we're hearing from Jeremy, from Jessica, from Jill, from Michael, is that is a question, which is why I said in my remarks, the application of the jus in bello of LOAC into space, it clearly applies, but we have to work out how, because the proportionality issue is so tough, right? Taking out one satellite, let's say kinetically, to make the extreme example, creates debris, so the proportionality of that. And let's say that's a dual use satellite on which many people are dependent on for their infrastructure. It also has consequences. And I know Michael will respond, and hopefully he'll elaborate on the points that I'm making very generally. So I think there's many questions before they could even contemplate doing it, but even if they feel they have a legal right to do so, I'm not sure they could do it unless they can satisfy themselves on that proportionality issue. And as we're discovering, it's unbelievably difficult to do that, and which is why I think, I posed my initial question. Thank you, Peter, and I'm sure Michael will correct everything that I've said incorrectly. But back to you.
I can see that Michael is anxious to be able to join issue with you. So why don't we go right to you, Michael? Any thoughts on both the issue of the right of self-defense as well as Stephen's observations on kinetic and anti-satellite weapons?
Yeah, well, I actually want to agree with Stephen that that proportionality is the key, and proportionality is a requirement both under the law of self-defense and the so-called jus ad bellum, the law governing recourse to force, and also proportionality is central to the jus in bello, to the international law of armed conflict, or perhaps better, the international humanitarian law governing actions during an actual conflict. So proportionality is central. And when you connect not just the fact that there's the creation of debris, but that debris can then result in knock-on collisions and collisional cascades, that a kinetic conflict in low Earth orbit could result in the loss of safe access to important regions of low Earth orbit for decades or even centuries. And the proportionality test cannot be met. And the reason it cannot be met is precisely what we heard in terms of the importance of low Earth orbit for all kinds of civilian activities and services. If we lose low Earth orbit, we lose all the Earth imaging satellites that support agriculture. We lose the satellites satellites that facilitate things like search and rescue and disaster relief. It's not just about the convenience of your ATM, it's about the actual survival of hundreds of millions of people. And that is a readily foreseeable consequence of a kinetic war, armed conflict in low Earth orbit. And so no, I don't think you can meet the proportionality requirement with regards to self-defense, even though at first glance, the satellites are incredibly attractive targets because they're the eyes and ears of militaries, and there are no human beings on board, right? There's no immediate loss of life. But when you do the proportionality requirement, as a result of space debris and the so-called Kessler syndrome, the collisional cascade risk, and I think you have to rule it out. And the same thing with regards to the use in bellow. Yeah, RadarSat-2 meets the first test, but it doesn't meet the second one because it's a massive satellite. It's at 800 kilometers altitude, and the consequences for civilians over time would be absolutely devastating. In terms of the customary international law that I spoke about, Stephen, I talked about it as something that was in development. There's an awful lot of state practice and opinio juris if you go digging deep. And Aaron and Boley and I have a book coming out in just 2 months that has an entire chapter that goes deep into that analysis of state practice and opinio juris. And quite frankly, we found a lot more than I expected in support of this developing rule against the testing of kinetic ASAT weapons that cause long-lasting debris. Thank you very much for the chance to respond.
And Michael, you actually also, I think, responded to a second question in our chat room about commercial activity. So thank you for doing that as well. That a twin response, very, very helpful. And let me just ask the other panelists if you have any comments or observations on the dialogue between Stephen and Michael. Any thoughts, Jessica or Jeremy or Gilles? Start with Jeremy.
Yeah, thank you, Peter. Just in terms of this conversation with respect to attacks on satellites, one of the things that I wanted to mention, and I know that Gilles emphasized this quite a bit, I loved the slide with respect to the kind of conflict continuum that he threw up. And so I think that plays a very important role in this discussion of targeting satellites. You saw the slide, right, that Gilles had, the kind of spectrum of conflict there. And if you know anything about, right, kind of the space doctrine, certainly of the United States, for example, we have, I think, what are known as kind of the 5 Ds, and hopefully I'll get these mostly in order, right? Deceive, disrupt, deny, degrade, and destroy, right? Kind of following that same spectrum and continuum that Gilles demonstrated right on that slide. And I think that, right, we've really focused in on the destruction of satellites, right? And I know that Rajul's question from the chat specifically said destroy. I do think, though, that states have a wide array of options in responding, right, militarily to space systems, and that the actual kinetic destruction of a satellite is not necessarily perhaps even the most desirable way in which a state would choose to attack a satellite if they wanted to. I mean, largely for many of the reasons that have already been discussed: creation of debris, the fact that it's harmful to everyone, proportionality analyses. But you could affect that satellite, or you could potentially affect that satellite's capabilities, right, in other ways. And so I think that spectrum of response, right, whether you could somehow degrade that satellite's capabilities to either a cyber attack or, as Gilles mentioned, a laser dazzling attack, something like that. I think that makes the question of targeting satellites one that is much more nuanced than simple destruction, which I think also gets to the question that Stephen posed, right? Could a purely terrestrial attack engender, right, a self-defense response in outer space? Being the military member on the panel, right, this is probably the stereotypical military response that you get all the time, Stephen. So I would say, though, that I think it could, right? Again, depending on the circumstances. However, I don't think that would necessarily mean kinetic attack on a satellite, right? But if there was such a military advantage from targeting an adversary's satellites, right, going after its satellite-based command and control, going after its eyes and ears, right, in space to try and degrade its capabilities in that manner, to such a degree, right, that you would have a terrestrial military effect, and that was a proportionate self-defense response. I think that there are non-kinetic ways that you could do that. You could target these space systems that probably would satisfy the requirements of proportionality, largely because they would be non-kinetic. And so that's all I would have to say about the current discussion so far. So Peter, I'll turn it back to you. Thank you.
Thanks, Jeremy. And that corresponds to an additional question we had, if I understand correctly, what your view is, and maybe ask Gilles also, the idea of jamming or spoofing, especially if it can be done, say, terrestrially, that would avoid then the issue of the proportionality concern with respect to a kinetic action. Is that a fair statement? Maybe Gilles, you could comment on that.
Thank you. Potentially, yes. I mean, I'm assuming the context here is within an armed conflict, because if you're not within an armed conflict, the rules are all very different. But it would certainly make the proportionality test easier to meet, because you're not creating that long-lived debris. Now, jamming again can be nuanced in terms you can, in some cases, interfere with perhaps the military service only, without necessarily interfering with the commercial service. Stephen mentioned Optus C1, which has a commercial payload and a military payload. Those are independent payloads, and the military frequencies are different from the commercial frequency. So in that particular case, you could target and jam and interfere with the military function and leave the civilian function alone. Many other cases, the military users are mixed in with the civil users, and that would not be so easy. If the satellite was providing some type of essential service, let's say some kind of telemedicine service, weather warning, tsunami warning, what it was monitoring SCADA systems that are used for energy distribution. It was monitoring water levels, which are related to dams and functions of flooding. There's still a possibility. You'd still have to look at that, still have to do that proportionality analysis, but you wouldn't have to worry about the debris part. The big challenge is understanding who the other users are on the satellite and how critical that function is to civilians and non-combatants. And that is not a simple task. If you look, for example, the cyber attack on the Viasat satellite that we're all familiar with at Ukraine, they were targeting, the cyber attackers were targeting the modems of the Ukrainian Ministry of Defense users on that system. But they were all intermingled with thousands of other commercial and civilian users across Europe. And they weren't able to differentiate. We're only going to attack the military ones. So it solves the problem of debris, but it doesn't totally solve the proportionality question, because it's very specific to the case. And I think in many cases, it would be almost impossible for the attacker to perhaps understand. He would need to have a lot of intelligence to understand the ramifications of interfering with the entire functioning of the satellite. So I'm using an example of a communication satellite. So in other cases, if you're looking at RadarSat, since it was brought up, use a synthetic aperture radar to create images of the ground. So if you're wanting to interfere with it within the vicinity of the conflict area, you could actually interfere with that radio frequency signal that's used to create the images. And that would only interfere with gathering the synthetic aperture radar images in that area, and it would leave the satellite untouched, and it could continue with civilian, functions elsewhere in the world, such as ice monitoring or ocean monitoring elsewhere. So very case specific, you need a lot of knowledge, I think, in order to make a confident assessment of proportionality. Thank you.
Thanks, Gilles. And it certainly corresponds with what both Stephen and Michael have said in terms of it being very fact specific. If I understand the example that you gave in terms of jamming signals, if, for example, they related to the military frequencies or frequencies that are allocated to the military, that may be one way of differentiating that from affecting radio frequency transmissions that are otherwise used by civilians or for commercial purposes. And in that instance, there may be a better argument for proportionality as it relates to jamming or spoofing. But that's quite interesting. Jessica, any thoughts or comments to what you've heard on this?
Yeah, I think that, well, the discussion on all the technicalities is really interesting. And again, I think it points to a gray area where there's a lot of nefarious activity that can take place in space that is not necessarily armed conflict and is not necessarily captured by illegal versus legal. The scope of what is legal in space is broad. And I think that's part of the norms discussion. And I think building on what Michael said and what Stephen said, norms and law, again, this isn't an either or. They're deeply related. And Almudena and I make that point in a Unidir paper on norms about the relationship between norms and customary international law. They're not opposing to one another. But in terms of, bringing law back in, I think Stephen's absolutely right. And I think that's what is valuable right now about the UN open-ended working group, is it's trying to get around this either or between law and norms that have plagued the international community for a long time. It specifically started with the discussion of what is existing international law as it applies to space. What are the key principles that we can build on? And what I think one of the only things that everyone is agreeing on so far, Stephen, is the fact that international law applies in outer space, which A, it's great that we're agreeing. B, I hope we can move the envelope a little bit more in terms of what can be agreed on. One thing that is not fully agreed on is international humanitarian law, mostly because of a bit of a catch-22 where some states insist that warfighting itself is illegal in space. And so we cannot say that IHL applies, and you get kind of caught up in this roundabout. But, I think making better use of the laws that we have is really a key goal of a lot of advocates of norms. We have excellent principles in the Outer Space Treaty. We haven't made very good use of many of them. And I think what's exciting to see with the norms discussion is the focus on Article 9 and due regard. So what do these principles look like in practice? How can we implement them in a way that can stabilize the space environment, make others feel reassured about our intentions, and create new mechanisms to address rising tensions if we are perceiving threats in space. And so much of that is just lacking. So I think we have great legal tools. We could probably develop more, but we certainly don't make enough use of what we have. And so that's kind of what excites me on the dynamics between law and developing norms in space. And I think that's where the open-ended working group is going. The politics are a little bit different, but the substance has been really invigorating. So I'll leave it at that.
Thanks very much, Jessica. And we have about 10 minutes left if there are any additional questions. I had one specifically for you as well, but let me first ask Michael and Stephen. I know you've got some maybe some quick follow-on comments to what you've heard. Michael, let's start with you.
Can you hear me now? I'd just like to speak very briefly to the issue of jamming. There's a lot of jamming happening right now. Try to get a reliable GPS signal anywhere from northern Norway to southeastern Europe, and it's not easy because of the conflict in Ukraine and tensions along that entire frontier with Russia. But jamming does not constitute an armed attack, right? It does not trigger a right of self-defense. It's still illegal. It's an infringement of the freedom of exploration and use of space. But this is an example of why it's so useful to have general international law, to have the jus ad bello and the jus in bello existing in parallel with space law, right? So yes, you can take measures to address illegal actions that don't rise to the level of armed attack, but you don't risk an escalation into a full-blown nuclear conflict between Russia and the United States. I just wanted to make that point, that all this stuff is illegal, but some has more serious consequences than others. And the last thing I'll say, just in case I don't get a chance to say it before the end, it's really, I think, reassuring that there is still cooperation happening in space between Western countries and Russia. There are still cosmonauts and astronauts working side by side on the International Space Station. The COSPAS SARSAT search and rescue program is still working with participation from all countries. The Disasters Charter is still working with participation from all countries. Space is a place where we're worried about armed conflict taking place and escalating, but it's also one of the rare places where there is still working cooperation between Russia and Western countries.
Thanks for those observations. Stephen.
Thank you so much. I'll be brief. Firstly, let me just echo Michael's comments about how important that to have ongoing dialogue, even in the most dire of circumstances, is really important. And we're even seeing that at the COPOS, that discussions are tough and there are sometimes, walkouts and things like that, but we're still able to achieve consensus on some major issues, even in these terrible times. And so I think dialogue is important. The point I wanted to make is building on what Jessica said about law. So you'll all recall that late last year, China, through the United Nations Secretariat of COPOS, put in a note verbal where they criticized or made some points regarding to activities of two Starlink satellites and alleged close proximity and danger to the Chinese space station and endangering the Taikonauts. Now, putting the facts aside, because I know that's been disputed, etc. But what China did was really interesting. They made that note verbal and they used the law, and it was a powerful argument. They used Article 5 of the Outer Space Treaty, which, historically we haven't really thought about in these terms. Used Article 5 of the Outer Space Treaty to make these allegations. And it, again, putting the facts aside, that's a different issue. That's a really powerful way of using the law. And I have to say, the response that the United States put forward didn't really talk about law, didn't respond on a legal framework, but said, hey, we looked at this, we didn't consider there was any possibility of problems. We considered it was okay. And I think it's dangerous to ignore, to move away from the moral high ground that law represents, because issues about what is responsible, and what, in my opinion, is safe and what is not safe, etc., have much more subjectivity about them. And that's the criticism of the process from many of these countries, that, what I think is responsible, what does responsible mean, because you have different concepts. Law is a bit different. Of course, there are different interpretations of the law, but it's a powerful thing. No country wants to be told that they violated law. And I think it's important to recognize that and build on that. Thank you for giving me the floor again.
Thank you, Stephen. Let me just get back to Jessica. One point that has been addressed in a number of the comments and observations that I have particular interest in. Maybe you could give us some guidance on norms and rules governing state responsibility and for determining state liability in the conduct of space military activities and actions. Can you give us your thoughts on that, please?
I'm not the right person to ask. I actually think that's a legal question. And I know Chris Johnson's written a paper, I think, recently on this, but liability law is being explored in a more creative way lately as a way to, I think, push back on some of the, let's say, less responsible activities that might be happening in space. It's not coming up very frequently at the open-ended working group. It's being slotted really into that legal box, if you will. But I think that it, to me, shows the opportunity either, as Stephen says, to think creatively about international law and how we can apply it. But also maybe building norms. Again, to me, liability is very very legal because there's also the separate liability convention. So Stephen's probably anxious to get in there on this. And I don't know if Chris is in the room at all. But I think that there's opportunity for state practice to set standards of responsible behavior that are in line with law. I'm not sure if states are adopting very many national. I think the adoption of national legislation is a really key example through which we can put existing legal practices into practice. And I'm not sure if too many states are starting to think about the liability questions associated with some of the new technologies, such as active debris removal and satellite servicing, and what that might mean and how they're going to respond to claims of liability. But I think that putting that in place would be a way of demonstrating leadership. On a different element, I know that Japan is really leading the way when it comes to transparency. And again, that's more of a norms approach, not a law approach. But their sort of motto of radical transparency when it comes to the use of emerging dual purpose technology, I think is phenomenal and really sets a bar of responsible behavior, if you will, when it comes to certain activities. But Stephen might want to get in there on liability. I just don't have the legal background.
Sure. And any thoughts on that, Stephen or Jeremy or others on that question?
I think our liability regime that we have, both under the Outer Space Treaty and the Liability Convention under the Space Principles, need upgrading. You know, for example, in the work that I'm doing in the working group on space resource activities, you could certainly postulate an argument where some damage is caused on the surface of, let's say, the moon, and the liability arrangements may not apply. The existing, so we need to build on that. When it comes to military activities and quote unquote liability and compensation and what follows from that and reparations, not only are the space treaties perhaps relevant, but also other areas of international law. In terms of responsibility, this is a bit of a bugbear from me because people look at the sui generis responsibility provision in Article 6 of the Outer Space Treaty and they say, that's it. That's what responsibility is. There's nothing else. And, you know, we don't have time now, but let me assure you that state responsibility principles under general international law also apply to space activities, and they may be relevant in the area of military activities, but we would need another 2 hours to talk about that. But thank you for giving me the floor.
Thanks, Stephen. We only have a couple of minutes, actually. Any thoughts, Jeremy or Gilles, before we hand the floor back to Stefan Michael?
So just a really brief comment, Peter, with respect to the issue of liability, right, as Stephen was just mentioning, vis-a-vis the actors in an armed conflict, I mean, you wouldn't really see the issue of liability come up. I think that if we're talking armed conflict in outer space causing potential damage, right, to neutral parties, liability, or as Stephen said, reparations, might be more of an issue. That said, I think that the issue is one that is so complicated that really, you know, there's no good answer to it at this particular point in time. Really, we have the liability convention, but, you know, with kind of conflict of laws in the case of, you know, what applies during an armed conflict, whether or not the liability convention would even be applicable vis-a-vis a neutral party against one of the belligerents, I think is an open question. So those were just my basic, not particularly helpful comments, but I wanted to throw that out there. Thank you.
Very helpful. Thanks, Jeremy. Gilles, any final thoughts?
Well, just the last one on liability. This would be outside of an armed conflict. So we have the Liability Convention, Article 3, which is fault-based liability for damage caused to a space object by another space object. And we don't understand, normally in liability, you're at fault when you didn't act in accordance with enough caution, or you didn't follow the standards. And in space, we don't have those standards, those agreed upon standards of operation, which you can say, oh, you're at fault because you did not operate with sufficient regard and you didn't follow the operating standards. So I think we still need to establish those standards of operation for safe operations in outer space, which includes, information sharing and various things. And I think that perhaps that's where the commercial sector can lead us by, practice and establishing that. But that would be outside of the armed conflict. Within the armed conflict, I agree. With Jeremy, that's a whole different discussion that I'm not familiar with the rules there. So that's all for me. Thank you.
Thank you, Gilles. And we're out of time now, but before turning the floor back to Stefan Michael and to Donald, let me thank each of our panelists for a very informative session. I certainly learned a lot, and let me thank you on behalf of all of the participants, and also thanks to Donald and Stefan Michael for this opportunity to organize such an interesting webinar. Really appreciate McGill Institute of Air and Space Law in having organized this. So let me turn it back to you, Stefan, for any concluding remarks.
Thank you very much, Peter. On behalf of the Institute, to all of the speakers and to you, Peter, as the moderator, thank you very much for generously donating your time and to speak to us. It was a very engaging session, very interesting subject matter, a lot to discuss. So thank you very much. The recording will be uploaded to YouTube very soon, and you will find the link to the YouTube video on our website. So thank you very much.
Okay, thanks,
Bye-bye,
everyone.
everyone. Thank you. Stay safe.
Bye-bye.